The defendant looked the judge in the eye and said, "I am innocent." 30 seconds later, he was sentenced to 30 years in prison. He had just entered an Alford plea. And what happened next reveals a disturbing truth about American justice. November 1970. Henry Alford stood in a North Carolina courtroom facing first-degree murder charges. The prosecution had witnesses. They had motive. They were seeking the death penalty. Alford's own attorney told him the evidence was overwhelming. He had a choice. Go to trial and risk the electric chair. Or plead guilty to second-degree murder and get 30 years. But here's where it gets strange. Alford refused to admit he killed anyone. He maintained his innocence while simultaneously pleading guilty. The judge accepted it. And this impossible contradiction would eventually reach the highest court in the land. But the question that haunted everyone was this: how can the justice system convict someone who says they didn't do it? To understand why Alford made this choice, you need to understand what he was facing. In 1965, a man named Nathaniel Young was shot and killed in North Carolina. Witnesses placed Alford at the scene. Some claimed he confessed. The physical evidence was damning. If this went to trial, Alford's attorney believed he would lose. And in 1970, losing a first-degree murder trial in North Carolina meant one thing: death by electrocution. But second-degree murder carried a maximum of 30 years. If Alford pleaded guilty, he would live. If he maintained innocence at trial, he would likely die. Think about that for a second. The system forced him to choose between truth and survival. If this is making you think differently about plea deals, drop a like. His attorney presented him with brutal math. A 99% chance of conviction versus guaranteed life in prison. But here's where the story takes an unexpected turn. Alford entered his guilty plea, but he did something no one anticipated. He stood before the court and explicitly denied committing murder. Word for word, he told the judge he was not guilty. His exact words were, quote, "I just pleaded guilty because they said if I didn't, they would gas me for it," end quote. The prosecution was furious. The defense was nervous. But the judge had a decision to make. Could a court accept a guilty plea from someone actively proclaiming innocence? Now imagine you're that judge. You have a man pleading guilty to save his life while swearing he didn't do it. Do you accept the plea or demand he choose one position? The judge accepted it. He sentenced Alford to 30 years. And that decision would be challenged all the way to Washington. Alford's attorneys appealed immediately. They argued that a guilty plea cannot be voluntary if it's coerced by the threat of death. The Fourth Circuit Court of Appeals agreed. They vacated his conviction, ruling that Alford had been forced into an impossible situation. The state of North Carolina was outraged. They appealed to the United States Supreme Court. And in 1970, the 9 justices agreed to hear the case. North Carolina versus Alford would determine whether the American justice system could accept guilty pleas from defendants who maintained innocence. The implications were massive. Thousands of cases could be affected. And here's what nobody talks about. The Supreme Court wasn't just deciding Alford's fate. They were deciding whether survival could legally override truth. The answer they gave would reshape criminal law forever. But that's not even the most disturbing part of this story. In a 6-3 decision, the Supreme Court ruled that guilty pleas from defendants maintaining innocence are constitutionally valid. Justice Byron White wrote the majority opinion. His reasoning was coldly pragmatic. He stated that the Constitution does not require that every guilty plea be accompanied by an admission of guilt. As long as there is strong evidence of actual guilt, as long as the defendant understands the consequences, the plea stands. And here's what changes everything you just heard. The court essentially ruled that legal truth and factual truth can be different things. A man can be legally guilty while maintaining factual innocence. If you want to see how this decision has played out in real cases since then, make sure you're subscribed. The dissenting justices called this a travesty. But the majority prevailed. Since that 1970 ruling, the Alford plea has been used in some of the most controversial cases in American history. The West Memphis Three. Damian Eccles, Jason Baldwin, and Jesse Misskelley spent 18 years in prison for murders they claimed they never committed. In 2011, with new DNA evidence casting doubt on their convictions, they were offered a choice. Stay in prison fighting for exoneration. Or enter an Alford plea and walk free that day. They took the plea. They're free. But legally, they're still guilty of murder. Michael Peterson. The novelist convicted of murdering his wife. After a retrial was ordered due to prosecutorial misconduct, he entered an Alford plea in 2017. He maintained innocence. He served no additional time. But his conviction stands. Drop your prediction in the comments. Do you think these defendants were actually innocent? And this is the fundamental problem the Alford plea reveals about American justice. It exists because our system would rather have a conviction than the truth. Prosecutors get their win. Defendants avoid maximum punishment. Courts clear their dockets. Everyone benefits except justice itself. Consider this. If a defendant is truly innocent, the Alford plea allows the real perpetrator to remain free. If they're guilty, it allows them to never fully accept responsibility. Either way, nobody gets actual justice. Some states have recognized this problem. Indiana, Michigan, and New Jersey have banned Alford pleas entirely. The federal government restricts their use. But in most states, this legal contradiction continues every single day. Courts across America are sentencing people who stand before judges and say I did not do this. That's the truth about the Alford plea. Henry Alford himself was released from prison in 1987. He died in 1975. Wait. That's not a typo. Alford actually died while still incarcerated, never experiencing freedom after his plea. The man whose name became synonymous with this legal paradox never saw its full impact. He never knew that his desperate choice to avoid the electric chair would be invoked thousands of times. Every year, countless defendants enter Alford pleas. They say I'm innocent but I'm accepting guilt. And the system lets them. Because our courts have decided that efficiency matters more than truth. That closure matters more than justice. Henry Alford's legacy isn't just a legal precedent. It's a mirror reflecting what our justice system truly values. And now you know the real story behind those headlines you see. The ones that say defendant pleads guilty while maintaining innocence.